In the United Kingdom over the last 10 years or so, there has been an almost unprecedented engagement of the courts with issues surrounding national security. Pressure in the post-9/11 atmosphere has been at its most pronounced on the central features of a fair trial. And when one speaks, of course, of the right to a fair trial, many think of a criminal trial. But the reality of the so-called war on terror in the legal context is that for the most part, the battle over fundamental rights has not been fought in the criminal law arena. Thankfully, at least thankfully in my view, the criminal trial has thus far remained largely untouched by the problems of evidence that the state deems too sensitive to disclose. Instead, what has exercised the courts on very many occasions has been the treatment of those whom the state suspects of involvement in terrorism, but either is not able to or has elected not to prosecute. The range of measures that the state has used in relation to such people is extremely wide. And those measures have taken the courts into unprecedented territory. We've had to deal with complex arguments about the legitimacy of procedures which strike at the heart of traditional common law rights. Contrary to popular belief and what one might expect, the Human Rights Act and the European Convention on Human Rights have not always occupied center field in all of those cases. But measures ranging from straightforward detention without trial to asset freezing to protracted attempts at deportation on grounds of national security all have been involved. And into that heady mix is thrown the traditional civil claim where evidence that touches on national security issues brings it squarely into the debate on the right to a fair trial. Now, an obvious starting point in my brief review of the major cases is that of A and others against the Secretary of State for the Home Department decided in 2004 by the House of Lords. Fair trial issues did not in fact lie at the heart of the case, but it nevertheless represented the beginning of what might be described as a long tug-of-war between the courts and the executive as to the rights of suspected terrorists to disclosure of material on which decisions adverse to them had been taken. And a panel of 9 law lords in the Judicial Committee of the House of Lords decided in that case that legislation which had allowed the government to preemptively lock up a number of foreign terrorist suspects in Belmarsh prison without charge or trial was incompatible with the Human Rights Act, and that their detention was, in consequence, unlawful. And in a passage that forcefully summed up the full reality of the scheme, Lord Hope of Craighead said this. He said, "An individual who is detained under Section 23 of the Anti-Terrorism, Crime and Security Act of 2001 will be a person accused of no crime, but a person whom the Secretary of State has certified that he reasonably suspects is a terrorist. The individual may then be detained in prison indefinitely. True it is that he can leave the United Kingdom if he elects to do so, but the reality in many cases will be that the only country to which he is entitled to go will be a country where he is likely to undergo torture if he goes there. He can challenge before the Special Immigration Appeals Commission the reasonableness of the Secretary of State's suspicion that he is a terrorist, but has no right to know the grounds on which the Secretary of State has formed that suspicion. The grounds can be made known to a special advocate appointed to represent him, but the special advocate may not inform him of the grounds and therefore cannot take instructions from him in refutation of the allegations made against him. Indefinite imprisonment in consequence of a denunciation on grounds that are not disclosed and made by a person whose identity cannot be disclosed is the stuff of nightmares, associated, whether accurately or inaccurately, with France before and during the revolution, with Soviet Russia in the Stalinist era, and now associated as a result of Section 23 of the 2001 Act with the United Kingdom. Strong stuff indeed. And notwithstanding, in 2004, the long shadow cast by the events of the 9th of September 2001, the House of Lords unanimously was unequivocal in its denunciation of the legislation. The executive had simply gone too far. Now, the latter part of the passage that I've quoted from Lord Hope's speech revealed the besetting problem that has since been the source of controversy when the state has sought to place restrictions on those deemed to present a threat to national security. Material on which the state wishes to rely but does not want to disclose to the affected party or the wider public has come to dominate the legal argument in the government's attempts to control those that it sees as a threat. Such material is variously described as closed, secret, or contrary to the public interest. Ultimately, however, it concerns evidence that may be used to restrict an individual's liberty, or to remove him from the country, or to defeat a civil claim which he may take against the state, or to control his financial activity. And all of these measures are taken without giving the individual a chance to see or contest the evidence, other than through lawyers appointed by the court who may not communicate with the party whose interests they are supposed to represent. Now, some of the aspects of the case of A and others featured in a subsequent application by the appellants in that case to the European Court of Human Rights in a case that became known as A and others against the United Kingdom. And that resulted in a landmark decision by the Strasbourg Court, about which I have something to say presently. In the meantime, however, as a result of the House of Lords decision, the men who had been imprisoned in Belmarsh were released. Some of those were placed under control orders, a term that we're now familiar with, but which at the time was a novel concept in United Kingdom law. And those control orders sparked a series of decisions in the House of Lords and later the Supreme Court as to what exactly a person who was subject to a control order may know of the case against him. Parliament had legislated to specifically restrict the right to disclosure of evidence for those who were made subjects of control orders. And the principal issue in the series of cases which ensued focused on the requirements of Article 6 of the European Convention on Human Rights and the fair hearing guarantees which Article 6 enshrines. And as part of the new dispensation of control orders, the phenomenon that I've referred to already of special advocates emerged into full flower. These were specially chosen lawyers who were permitted to view the closed evidence on behalf of the suspect. They were allowed to challenge it or to claim that it should be disclosed. But they were not, and currently are not, permitted to discuss the material with the suspect. Notwithstanding those constraints on the ability to represent the suspect, the Secretary of State argued that the introduction of the special advocate scheme into the equation provided sufficient guarantees of procedural fairness for the suspect. And it was the government's position that no further open disclosure was required. Now, the picture that emerged from the various decisions in which battle was joined on this adequacy of disclosure, the picture that emerged from the decisions, I have to say, with the benefit of hindsight, of course, was not entirely free from ambiguity. First of all, in the case called the Secretary of State against MB, the House of Lords left open the possibility that the subject might be given a sufficient measure of procedural protection, even though disclosure of the whole evidential basis for the basic allegation against him had not been made. In a later case, a majority of the Court of Appeal in AF number 2 stated that there is no principle that a hearing will be unfair in the absence of open disclosure to the controllee of an irreducible minimum of allegation or evidence. And so, despite the robust language of Lord Hope in the original decision in the Belmarsh case, those who had previously been locked up now found themselves under very restrictive control orders, but still without much of any knowledge of the case that was made against them. There began to emerge, however, the notion of a core irreducible minimum of disclosure, or as it is sometimes inelegantly called, gisting. And when Strasbourg gave judgment in A and others against the United Kingdom, it held that where a decision to certify suspects as international terrorists under Section 21 of the 2001 Act, with all the consequences that that had by way of detention without trial, where such a decision was based solely or to a decisive degree on closed materials, the procedural requirements of the Convention would not be satisfied. And in rejecting the Secretary of State's contrary argument, the Court went on to say this. It said, the Special Advocate could perform an important role in counterbalancing the lack of full disclosure and lack of a full open adversarial hearing by testing the evidence and putting arguments on behalf of the detainee during the closed hearings. However, the Special Advocate could not perform this function in any useful way unless the detainee was provided with sufficient information about the allegations against him to enable him to give effective instructions to the Special Advocate. So in effect, what Strasbourg was saying was that although the Special Advocate system could go some way towards mitigating the effect of non-disclosure, ultimately there came a point where, in order to comply with the minimum guarantees of Article 6, sufficient information of the case against him had to be supplied to the suspect in order that he could give informed instruction to the Special Advocate. That this was the minimum requirement was later acknowledged by the House of Lords in the subsequent case of AF number 3. Now, it may be a matter for debate, but it seems to me that the acknowledgement that the House of Lords made might be seen in retrospect to be no more than one would expect in light of our common law tradition. If someone is to be detained in prison, or if he is to be the subject of a control order which so curtails his liberty as to amount to a form of closely confined house arrest, is it not obvious that he should have the chance to know and to challenge the basis on which the decision so to confine him has been taken? And the answer that is sometimes given, and is frequently given, to the effect that to reveal the basis for detention would imperil national security, that answer, as it seems to me, cannot be, without more, a complete response. A balance between what at first blush might appear irreconcilable positions has to be struck. And it's true, of course, and I'm the first to acknowledge it, that no perfect solution is possible. But the fact that no perfect solution is possible does not relieve the courts or the executive of the obligation to strive for the solution nearest to perfection that can be achieved. So one might have expected that much of the debate in subsequent cases would have